Assalamualaikum warahmatullahi wabarakatuh. This is our first recording lecture. So this is my first attempt. Actually, I want to finish the topic on misrepresentation that we have covered together in the class. So we'll try to see how it goes. So if you still remember, we have covered most of the parts of the misrepresentation. We covered definition, we covered conditions thoroughly, okay? And then under the topic conditions, we have subtopic of silence, and we covered also very detailed on inducement, okay? Because in most of the situations, the court or the law imposes such a heavy burden on the part of the buyer, okay, before they decide or before they can proceed with the transaction. And before the holiday, the break, basically we covered up to, what's the last part? Actually today my intention is to finish on the last part of our topic, which is okay, we covered types as well. Okay, types is very important because why? It will determine, okay, what are the specific remedies which the parties, okay, are entitled to, okay, the victim or the plaintiff. Okay, we covered fraudulent, okay, and then we covered negligent misrepresentation, and the last part is we covered wholly innocent misrepresentation. If you are not clear, you have to revise, or you can refer to the slides that I have given you. Okay, so for today, the purpose of the lecture, our lecture today is, this is the last part, okay, the effects and remedies. So as what we did in our previous topics, okay, whenever we discuss all the elements, requirements, and then the last part will be the effects and remedies. So for misrepresentation, somehow it is quite similar, okay, to the earlier topics, coercion, okay, undue influence that we covered together. So basically, whatever the topics, whatever the transactions or the contract which is affected by such vitiating factor, so what's the effect? It becomes voidable. So this is the same basically, okay, so it becomes voidable provided you prove all the two conditions that we have discussed together. So you can refer to your Contracts Act, section 19, subsection 1, and then that basically the effects, which is quite straightforward, but you have to know, okay, it's not really void, okay, it's voidable, which means that the parties has the option, okay, the choice whether they want to proceed or they want to put a stop. They can just set it aside, okay, the contract, so it becomes void. So the choice or the option is given to the victim, the plaintiff, okay, the affected parties. Okay, so once we know the effects, we want to know the remedies. Actually, in real situation, in practical situations, the remedies is the most important part. Because why? Okay, your client comes to you to seek for your advice, and they are asking for the remedies. So you must be able to advise them what's the most suitable, the correct remedies, okay, which is available to your client. So for the topic misrepresentation, we are going to discuss a little bit detail, okay, on the remedies. So basically, we have three types of remedies, okay, in which the court will allow the claims by the parties wherever relevant, okay. So we have the usual remedy of rescission, okay, from the word rescind, okay, rescission, and then we also have indemnity, okay, and also we also have damages. Okay, if you compare to our previous topic, coercion, undue influence, usually, okay, there's no remedy of damages or even indemnity. But for this topic, misrepresentation, these kinds of remedies could be available, okay, depending on which types or which categories of misrepresentation. Okay, so rescission, okay, from the word rescind. So we want to know what's the definition. Basically, the earlier, the easier meaning, the straightforward meaning is that if you want to rescind the contract, it means you want to set aside the contract. You don't want to proceed with the contract. Okay, and then this rescission or to rescind the contract here, it is available, okay, possible in all cases of misrepresentation. So what are the cases of, what are the types of misrepresentation? Okay, we have fraudulent, okay, we have negligent, we have wholly innocent, and this rescission actually is available to all these three categories. Okay, so what's the objective? Okay, the aim here is to put the parties back to their original position as though the contract had not been made, as if no contract from the very beginning. So that's basically the objective. You want to restore the parties back to their earlier position. And how it is being done? Okay, basically this is the procedure. Okay, the way to do it, the methods. Okay, basically the party, the victim, the injured party has to give notice to the other party. Okay, and then that one you can refer to section 67 Contracts Act, and you can he can also apply to the court under SRA, Specific Relief Act, specifically section 34. Okay, and then in relation to rescission here, in some situations, okay, there could be limitation, meaning that here, even though you are entitled to rescission, but there's certain circumstances, certain conditions in which it makes the party cannot apply. Okay, I mean cannot obtain the rescission. So there could be three situations here. Okay, we have 1, 2, 3. The first one is affirmation of the contract. Okay, and then the second one is restitution in integrum is impossible. I mean we cannot really restore you back to your earlier position. And then the third one is third party acquires right or bona fide purchaser for value without notice. So meaning that here, if the property, for example, rented property, the land, for example, has passed hands to the third party, and the third party here is the bona fide purchaser. They purchase, okay, with money, and then they are bona fide. No, I mean they are not party to the earlier transaction. Okay, without notice, bona fide, in good faith. Okay, and then we also have one specific case on this area, on the issue here. We have the case of Admiral Cove Developments, Berhad and Balakrishnan, Analaki, Devaraj and others. So here, despite the fact that rescission is available to all categories of misrepresentation, but again, in some situations here, like this case again, it's not available. This is a decision by federal court, so it's quite important, it's significant. So federal court held that property did not differ so completely in substance from what the respondent intended to acquire. So the court examined closely the whole facts of the cases here, and this is the conclusion. And the conduct, the way they hold themselves, the conduct of the respondents after accepting the keys to the property showed an election to affirm the agreement. So meaning that here, after they sign, this is pertaining to sale and purchase of certain condominium, and then after everything has been completed, all the formalities of all the documentations completed, after some time, after quite a number of years here, then only the purchaser, respondents in this case, they realize that actually this is not the property that they wanted to buy. Okay, they are not happy with certain circumstances surrounding the scenery of the relation to their condominium. So the court held that, well, the fact that there's a long lapse of time without complaint, so it means that from the legal aspect, actually it amounts to affirmation, as if you affirm the contract. So it's too late for you to complain later. You cannot really set it back. I mean you cannot set it aside. Set aside. You cannot really rescind the contract. Okay, and then the court, this case is also important because the court actually mentioned specifically about innocent misrepresentation. So this is actually the third category or third types of misrepresentation, and you can read actually all the point forms that I put in the box here. Okay, remedy was not available again because despite that this is the case of innocent misrepresentation, but because of the affirmation on the part of the purchaser, the respondents here, so it's too bad. You can't get the remedy. So it amounts to bars. You are being barred from obtaining the remedy. Okay, we move to this second category of remedy, which is indemnity. Okay, indemnity actually is very specific. Okay, it refers to money payment, okay, by the misrepresenter in respect of expenses. So it's all related to expenses, the actual money that you spend, okay, to pay, necessarily created in complying with the terms of the contract. So we have example here. The most common example, okay, usually involving sale and purchase of certain landed property, house or land here, okay. It include legal fees, okay, stamp fees, not necessarily the purchase money, okay, here. Legal fees, stamp fees, whatever fees here or whatever expenses in relation to completing all the documentation. So if your case is under misrepresentation, so you can actually claim this thing, okay, by way of indemnity, which is unique to the topic of misrepresentation. Okay, for damages, okay, it is also a lot. Okay, usually, okay, damages we haven't discussed the topic breach yet. Okay, we haven't come to that part yet. But usually, damages, a compensation is only allowed in cases of breach. But it is unique to the topic misrepresentation, provided the case falls under fraudulent misrepresentation. So meaning that here, if your case is under innocent misrepresentation, you cannot claim for damages. How do we know? From this case. Okay, this is the case which discuss about fraud or fraudulent. We are going to cover this is our next topic later. Okay, after we are done with this topic, we are going to continue with the topic fraud. Okay, we have the case of Abdul Razak bin Dato Abu Sama and Shah Alam Properties in Berhad, 1999. And the court held that, we zoom to the decision, okay, this is the focus. The court held that in the case of fraud, okay, the misled party, the victim, or usually the complainant, okay, is entitled under section 19 subsection 1 of Contracts Act, okay, to a decree of rescission and also to an award of damages. Remember, rescission is available to all three categories of misrepresentation. So on top of rescission, you want to set aside for the cases of fraudulent misrepresentation, okay, you can also ask for damages. So there are two remedies available for cases of fraudulent misrepresentation. Okay, alright, so again, the purpose of damages is to restore the victim to the position he occupied before the representation had been made. So usually the aim is to restoration, okay, to restore the parties back to their earlier position. Okay, so we are done with the topic misrepresentation. So hopefully you are able to follow my lecture, and we are going to have separate session to address all your queries, okay, or whatever things you want to ask. Okay, that's all. Okay, Assalamualaikum warahmatullahi wabarakatuh. Zarfan, how to stop?